morning, Graeme. In this extraordinary constitutional law week for the UK, let's talk about family law. Would you like to start by talking about your current practice and what is obviously very special about it? Would you like to share that with our audience?
Thank you, Rebecca, and good morning to everyone. I'm a partner at a firm called OGR Stock Denton, which used to be called Osmond, Gaunt and Rose, and I'm happy to say I'm going to be head of department there on the 1st of May.
Yes.
My practice there and the firm there has had a long history of seeking constructive and dignified outcomes.
And what does that mean?
What it means is that our approach to reaching solutions is really to try and find a more holistic approach rather than to go down the adversarial route. My colleague Peter Martin, who will be retiring, he's been there for about 40 years. He was one of the first solicitor mediators, and I'm hoping to carry through that practice, as I'm actually a collaborative practitioner, which is part of my work which I very much enjoy.
And what do you think that particularly brings to the solution of family problems?
Well, my experience of running cases collaboratively is that we tend to find solutions that clients find much more satisfying. They're much more involved in the process, and it's far less positional. And
in terms of success, do you have a good success rate with collaborative law? Because it has been somewhat controversial, hasn't it?
I understand the reason for the controversy, but I think that generally, by and large, the practitioners have all benefited from that in the way that we run our cases. We feel we're able to speak better to each other, and our clients feel much more involved. They can take sort of centre stage, and they can try and find solutions for themselves. And generally, I've had, well, pretty much 100% success rate.
That's wonderful. And how do you manage, you say the clients can take centre stage, how do you manage the power relationship? Because obviously it's the lawyers who know the law.
Yeah, but it takes a large amount of preparation of that work, and there's a lot of lawyer preparation that goes on in advance, and also speaking with the clients, but understanding what they need and what they're seeking is really pivotal to the whole process, and it needs to come through. But of course there is a legal aspect to it, and we have to guide our clients, but working all together, it seems to get to the heart of the problem more quickly.
Yes, and you've done a great deal for resolution, haven't you?
Thank you, Rebecca. Yes, I've been part of the organisation obviously for my whole career. I've been a solicitor now for 23 years, but about 10 or 11 years ago I went on the cohabitation committee, and I've been the chair of the cohabitation committee for about 4 or 5 years. And I've spent a large amount of that time training, speaking and writing on the issue of cohabitation, which has, I think, borne some fruit in the last few years in particular. And
what do you think have been the main problems you've had to confront and write about, talk about in the field of cohabitation?
Well, there are two central problems. One is that there's a lack of public awareness of the issue. In fact, when I entered the profession, it's fair to say I think there was a lack of awareness in the legal profession, let alone the public. And the second issue is the lack of rights. The fact that when people come to see me or they come to see other lawyers, it's too late in the day. They have no rights. When I say no rights, no automatic rights, and certainly no family law rights. And that's become a massive issue in this country because we now have over 6.5 million people cohabiting. So the situation is here, it's arrived, and we have to find a way of solving the problems.
And have you succeeded in bringing a collaborative law process to cohabitation, given the lack of rights, or does it not fit well with that?
Very unfortunately, it doesn't fit well because the law's not fair.
Indeed.
But we can use the collaborative process for negotiating cohabitation agreements, and I have done so.
Yes.
So it will work in a transactional situation. But in a situation where you're trying to resolve real live issue between the couple, you need better laws.
Yes, and I think we all find the law very difficult because it's not, as you say, I mean, it's not family-specific law, it's general law doctrines of property and equity law which are really stretched to their breaking point or not. in trying to achieve a family solution. It's not about fairness at all.
It's so complex. I remember when I was a student
Yes.
that I had to read it again and again and
Yes.
again on the morning of the exam. So it's a nightmare to understand, and to actually practice in it is very difficult.
Very difficult. Yes.
And essentially what we've ended up with is a very narrow area of law where it does apply, and we've imported concepts of fairness, but they're applied in a very complex way.
Yes.
And I think that what we've come up with now is almost a fictional scenario where judges, many years later, are imputing or inferring things, which essentially is a fiction.
Yes. And we have the problem, don't we, that the family court doesn't have any jurisdiction over Trust of Land Act claims, and so it's procedurally very difficult of where you actually start them.
It's incredibly complex, yes. I mean, we're using the CPR rather than the FPR.
Yes.
And these are concepts that family law practitioners aren't familiar with.
No.
And actually, it would be much better to run these cases using the family procedure rules and family law concepts, and also having the greater availability of processes such as mediation and collaborative law.
Yeah, I mean, I agree wholly. I mean, we've had 2 judgments from the House of Lords Supreme Court. We've had Jones and Kernet and Stack and Dowden, and then we've had Marr and Colley from the Privy Council, and it's still very, very difficult. And you get serious equity lawyers from chancery practices finding the law complex. So it's very difficult to explain to the lay client, I find, and I think we are all driven towards trying to settle even before issue because of the difficult consequences. So what has been achieved recently to try to remedy this pretty dire situation?
Well, I think there are 2 things going on. One is the research that's been done.
Yes.
Very recently by Anne Barlow.
Yes.
I think it's National Centre for
Yes.
Research, and also the work that's been done through Parliament.
Yes.
And I do feel that there has been. I am optimistic about the future with cohabitation in the law, because it is now being debated in Parliament. It's been debated in both houses over the last 12 to 14 months. And the research is out there, and the concept of the common law marriage myth is something that MPs are certainly becoming familiar with.
Yes.
Unfortunately, as has been borne out by the latest statistics, the wider public aren't
Still
aware. And I think it's now nearly half the population still don't know their rights. And more worryingly, it's that group of the population who are cohabiting and have dependent
Yes.
children who have almost the most lack of awareness. So
Yes.
it's not a problem that's going to go away.
And what is on the table in Parliament at the moment?
Well, we have 2 things going on. First of all, in the House of Commons, Tim Loughton's bill is now going to become law.
Yes.
It's had its royal
Would you like
assent.
to describe that to the audience? Because I think people are so rather alienated from Parliament by other matters, and so they may miss it. So if you'd like to tell us about that.
So Tim I think the history of this was a case, the Keedon and Steinfeld decision, and that was running through the courts for several years.
Yes.
And that's been running in parallel with a private member's bill that was put through the House of Commons by Tim Loughton. And the bit that family lawyers are there are actually other family law aspects, but the bit that we're interested for these purposes is the extension of civil partnerships to
Yes.
opposite sex couples, because there was a lacuna left by the same-sex marriage legislation at that time. And as a result of the Keedon and Steinfeld case, the Supreme
Which
Court...
didn't have an easy progress, did it?
Not at all.
It wasn't plain sailing. No.
Not at all, but academics that I know certainly felt from early on that they were going to win.
Yes.
And I felt fairly confident
Yes.
of that. And actually resolution, when the same-sex marriage legislation was going through, said, well, either you're going to have opposite sex civil partnerships or you abolish them. You can't have one and not the other.
No.
So it's clear it's going to be discriminatory. And essentially that legislation is to address that anomaly.
Yes.
And it's been successful, and I have to give credit to the people involved that they managed to get something through Parliament, because we know that passing any family law legislation is very, very difficult.
Very difficult.
But I think there's a difference here between introducing remedies that achieve equality and introducing remedies that achieve protection, protection against vulnerability. And certainly as a practitioner, that is the number one thing that I'm looking at, and I think most of our family law brethren are, is protecting those who are left vulnerable. Something that was addressed in certainly our divorce laws around 20 years ago at the time of the White and White decision. So really the difficulty is that I feel that the law is still discriminatory, certainly against mothers with dependent children. And unfortunately, the civil partnerships legislation will not address that vulnerability, and it won't address the lack of awareness that I spoke about a few minutes ago. Because those who are aware will enter into civil partnerships.
And those who are not aware won't.
They won't.
And also those who don't want civil partnership. So do you see any real prospect of general legislation to introduce family law type rights for cohabitants on breakdown of their relationship, both maintenance and property division? Do you think that's going to be a realistic prospect?
I do think it's realistic. I've been campaigning it for years, and I'll continue to campaign for it because I believe in it, and I think it will happen. It has happened in many other countries.
Indeed.
It's certainly happened in Australia and New Zealand, Ireland and Scotland. There's no reason it can't happen here. I think it's just the order in which it's happened. I think in England and Wales, we've been at the forefront of equality legislation with the same sex and opposite sex couples, but we haven't got onto the protection legislation. And it's different elsewhere. But the issue is that the demographics very clearly show that there's going to be a continued increase in the numbers cohabiting, certainly projected up to 2030, who knows after that. And we need to develop our laws to deal with that, because those are the cases that we see. Those are the cases that come in. And the fact is, that's how people choose to live their lives.
Oh, it's a very interesting point you make, that the distinction between equality legislation and, you call it protective, I call it remedial. And we have been very good in this jurisdiction about equality legislation. I think partly that has been driven, dare I say it, by the norms of the European Union, with same-sex marriage, etc. But we've been strangely reluctant to enact remedial legislation for institutions other than marriage, which the Law Commission, we know, has tried this several times and failed, and I find it very difficult to understand parliamentary reluctance about this, but it has traditionally been strong, and there's been traditionally a real fear about undermining the institution of marriage. What do you say about that?
I don't think there is any issue about that. I think that there are whole groups of people out there, that many people do want to get married. Nobody who supports cohabitation rights undermines the institution of marriage, but it is a choice, and there are other choices out there. And the reality is that people do live their lives in a certain way, and they're not. I think it's actually very presumptuous of the state and policymakers to assume that people will get married. Because life, unfortunately, has very different patterns now. I mean, we know that women are working in different ways, and we know that children are brought up in all sorts of families. And I think it's just ensuring that the law really is in line with the way modern society is.
Yes, you're quite right that there's an assumption that if people want to enter into a status, they will. But as you say, a lot of people aren't conscious that that status is available. They drift into relationships over many, many years, and something needs to be done at the termination of that. You don't think that Schedule 1 to the Children Act is a sufficient remedy at the moment?
Well, I did hear about this last week, actually, and there is a perception that they are being used more in low to middle value claims. But essentially my experience of it is it tends to be used more in cases where there is sufficient money available. And it's also quite a difficult remedy to pursue in terms of the procedural aspects that you have to go through. It very quickly becomes a disproportionate process, and it's all about ensuring sufficient provision for the child rather than the mother. So I think it's in the high value cases that we've seen the reported decisions. But I just wanted to go back to something earlier about when will there be a change.
Yes.
I think there is going to be a change in perception in the sense of, at the moment, I think there's a perception that it tends to be working class families that are cohabiting. But increasingly, as it's Middle England that cohabits, and perhaps even judges that cohabits, and perhaps politicians, then maybe they will see that becomes a norm, and they'll say, well, actually, those are perfectly committed and stable relationships, and actually there's every reason to give people in those situations a safety net if there are problems later on. No, I think it's an appalling situation for a woman to come to my office after 30 years of being in a committed relationship with 2 children and find that she is at risk of losing her home because she simply did not know what her rights are, and perhaps there was just nothing she could have done about it during that period. And I'll be right. And
to go back to the procedural complexities, given that the family court doesn't have any Tillata jurisdiction, you have real problems, and often one has to actually issue in the family division of the High Court so that you can get Tillata and Schedule 1 together, even in a low value case, which is absurd.
Yeah, absurd. I mean, the cost is hugely disproportionate in many cases. And the whole issue of cost budgeting is something that people find very, very difficult. It's certainly very difficult.
Would you like to talk about that?
Well, cost budgeting really is the process where, before one of the first directions appointment, you're actually projecting what the entire cost of the case is going to be. And it requires a lot of front loading, a lot of forecasting, building in contingencies. It's actually a very specialist piece of work. It's something that family lawyers find really difficult to do because things are so uncertain.
Yes.
And actually, if you're in a Tillata situation and there are children involved in the equation, it's very difficult to work out the contingencies. And it's very hard to run the case at that point.
What about fixed fees?
I think there might be some inevitability about that at a certain level, but I think that high value cases and complex cases will never sit well with fixed fees.
No.
And I think actually it's reasonable that lawyers get paid for their expertise and for their work.
Given the events going on this week and today, not as we speak, because we're speaking in the morning, but this afternoon in Parliament, I think I'd like to ask you your perception on Brexit and family law. I know Resolution's been very helpful to all the profession in keeping us updated with the challenges for providing advice, etc. But it's changing so much. What's your perception on the impact of the chaotic situation now for family law practice?
I think it's an incredibly difficult area, and it's an incredibly difficult time that we practice in. And I think it's for a number of reasons. I mean, I've been abroad a few times in the last few months, and my experience is that foreign practitioners, foreign lawyers, find it really difficult to get their heads around this. So what happens...
Where have you been? Which parts of...
I've been to Cyprus and Dubai.
Yeah.
And my experience is they just don't know how... I mean, 2 things. How are you going to do a business transaction involving the UK?
Yes.
Because that's the trade aspect.
Yes.
And secondly, how are you going to run a family law case? What happens if you've got a case involving one of the Brussels regulations, if you've got a case involving the maintenance regulation, and you've got a date sometime in May or June. I've certainly had to write to clients where there was a case going on in one of the other EU countries to warn them, and I think actually in that respect the resolution guidance was really good.
Yes.
But it's complex and it's cloudy. Nobody really knows where they were. I mean, there was a time when, not so long ago, when I did think there would be this transition period and we wouldn't be preparing for a no deal, but now nobody really knows. But I think there's also a greater impact on our practices in the sense of nothing really is getting done. So we can't get the new laws passed.
Yes.
that we need
Yes.
quickly, because Parliament is stagnated.
Yes.
And also we've got problems with business in the markets.
Yes.
And certainly, to my mind, the biggest impact that I'm seeing is on the property market.
Yes, definitely.
If the property market is downward, it has massive implications for law firms, because many law firms run on the basis that business is turning over. And secondly, it has a massive impact for our clients, because if a family home is being sold,
Yes.
there are sadly opportunists who will look to downward priced
Yes.
homes. And therefore, what I'm experiencing is people setting up quickly because they're scared
Yes.
of the price going downwards. So it's a terrible situation, and people don't really have clarity. And I think everybody knows it's a bad situation, but they can't find a way out of it. And it's about really providing some sort of comfort to our clients. But I suppose the one good thing is that in the area of family law, most of our substantive law won't actually be changed by Brexit. It's really only the areas where you've got jurisdictional aspects in the main.
I think what you're saying about the market is very interesting. I think both that causes difficulties both in relation to the valuation of a home which has been sold and the proceeds divided, however, but also the cost of rehousing. We just don't know. And the valuation is really not worth the paper it's written on, and that causes great anxieties, I think, with clients in financial remedy cases, particularly where the family home is the principal asset.
I mean, the day-to-day issues that many family lawyers are facing is that in a needs case, you're basically looking at where is a
and
mother...
most cases in the south are needs cases because the cost of housing is so great.
Yes.
Yeah.
But I think everywhere it is the family home is going to be sold.
Yes.
How am I going to ensure that my son or daughter are going to get to school, that they can be on the bus route, all of these things, and the sort of the uncertainty about it's just driving down the money. And then on the other side of it, you've got sort of businessmen saying, well, I can't project what my business is going to be worth or what I'm going to be able to do in the future. And certainly my partners at my firm have reported that they know of clients who would rather not invest at this time, that they're waiting to see what's going to happen. And it becomes damaging when it goes on for so long. And I do hope there's going to be a solution of some kind. I think the UK will be okay. That's my personal view.
But to go back to the difficulties in advising about the jurisdictional rules, I think those difficulties are really beginning to bite now, because under the crash out statutory instrument and the scheme of the Withdrawal Act, there's a transitional period, or the transitional arrangements for proceedings already started. But as you say, what is beginning to bite now is how difficult it is to advise a client who is contemplating starting proceedings, because we just don't know the rules. And so the consequence of that is having to give multiple advice, which is costly.
It's costly, it's confusing. And it's uncertain.
Yes.
And it could change on a daily or weekly basis. I mean, we still have to look at the situation where, as of today's date, there may be a no-deal scenario.
Yes.
And I have seen it written on several occasions that I think the government said that in that situation, please consult your lawyer.
Yes.
Why do they think that we will know the solution anymore?
Indeed. To move to something different, you've also been interested in the very thorny question of spousal maintenance. What do you say about that?
I think there's been a change, certainly during the period that I've been practicing, and certainly when I look at the awards that have been made. Obviously, on some of my cases, maintenance awards are made and then they're revisited and they're reviewed, and I've seen that there's definitely a change. There's definitely a move towards the imposition of a term.
Do you find that is that confined to London or generally?
I think it's general, but I've definitely seen it in London.
Yes.
And I think we're advising our clients differently as a result of it. I'm not sure it's always fair, and I think sometimes it's very harsh. But I think
harsh
there is a change.
Which side?
Well, you could be sympathetic. I mean, it's on a fact, it's on a facts basis, isn't it, on each case? But it can be, if you're a mother and you've had to give up your job and you're looking after 3 children.
Yes.
And then you're faced by this constant pressure of, well, the husband's thinking, well, actually, now I'm going to vary downwards. Now I've read this report in the paper. I'm going to go and do something about it. And there is a lot of stuff out there in the media about it. And people,
there is. Do you think the stuff in the media is an accurate representation of the case law?
I think that by and large we do have, the judges do exercise their discretion pretty well. And I certainly think that awards were more favourable 10 to 15 years ago, and now there's a closer scrutiny of the overall position. But I don't think it's right that it's used as an opportunity to do people down when they have a genuine need and they cannot actually rebuild their careers and they cannot possibly get up to a reasonable level. And
not in the current climate.
No, no. We still need to have protection.
What's the remedy for the extraordinary width of discretion we have and the difficulties we have advising the client as to the likely outcome, whether one's advising a husband about limiting it or a wife about getting a fair deal from her perception? What's the remedy for this width of discretion? I don't know. I want your wisdom.
But I think that in time we will see tariffs introduced in this country.
Yes.
I do think we will.
What exactly do you mean by?
So I mean, I think there's
do you mean a formula? Or?
Yes, I think there will be a formula. I know it hasn't worked great with the CSA or the CMS, whatever they now call it, but I think the idea of saying that it will be a percentage or it will be
a percentage of the payor's income.
Yeah, but I think it already is actually in reality.
So the old 1/3 rule is outdated, but can you see that in the pattern of decisions?
I think that's still in my mind. I think it's in lawyers' minds. I think it's in judges' minds as well. I don't think it's a perfect solution, and I think there needs to be a discretion retained in certainly a number of cases. But the difficulty we have in our justice system now is that, whether we like it or not, the process has been delawyered to a large extent. So for a large
What do you mean by delawyered?
Well, I mean, I think there are 2 things going on. First is digitisation of everything. So they're trying, I think they're eventually getting a divorce. Obviously it's different emotionally, but it's going to be like getting an MOT. You go through a series of processes and you get to your decree absolute, or you get whatever the decree of divorce, whatever they call it in the future. So that's one aspect where they're saying, well, actually, it's more of a robotic, mechanical issue.
Yes.
And the second thing that's happened, which is the elephant in the room, is that people tend not to use lawyers. Now, I think that's twofold. One, in the sense of legal aid being removed for most categories of family law, and it's only really available in very, very limited circumstances. Yes. And secondly, I think there is a category of professional, reasonably informed litigants in person out there who believe that they can teach themselves the law on the internet and go into court and try and do the case themselves, which I don't think is. You might say that I have an interest in saying that, but I don't think it works particularly well because our courts are not equipped to deal with it.
With spousal maintenance, what's wrong with a Scottish model, or what's being proposed by Baroness Deach, basically a term, whether it's 2 years, 3 years, 4 years, that's the matter, for the legislature, and then with a hardship exception. What's wrong with that model?
I just think that it's very harsh. It's like a guillotine. And I think our system is better at looking at situations of real need, and in particular where there are children and there is vulnerability, there does need to be a level of protection. And I think that if people know it's 3 years and that's it, I think people will panic. And
you don't think an exception proviso to the legislation would be a sufficient protection?
Well, it depends on how it's used.
Yes.
And how it's phrased. I think the point is discretion is fairer when the discretion is working well and when everybody understands what it means. And I think there certainly is scope to review the Matrimonial Causes Act, the Section 25. I mean, I think the time has come for that, but as you can see, Parliament's got other things on its mind.
Yes.
But it all feeds in, I think, to what we were talking about at the beginning, that if people understood their remedies more clearly,
Yes.
They could then adopt the processes of mediation, collaborative law, and they could reach certainty more quickly. And I
Yes.
think for the public, they would be very thankful for that.
You mentioned delawyerisation. What about de-courting? Have you got any observations about the apparent growth in private FDRs and the slow growth in arbitration? I know you're interested in
Yes.
in systems.
I think it is the way of the future. I think it's the way that our laws will go. I think that we are in a good situation in the sense that Resolution as an organisation, I think the FLPA as well, and other similar associations are very good with their training and very good at making our lawyers sort of fit for purpose in these specialisms, and they work well. But the point is they need to work using fair laws, and they need to be funded, and people need to afford them. But the reality is that the court is a brutal and harsh place for a lot of people, and when somebody is experiencing relationship breakdown, that's hard enough as it is. And then going through the legal processes sometimes just compounds that issue. And I think that actually going through processes such as arbitration, it's a far more humane way of finding an outcome.
To be devil's advocate, Graeme, I know that you're a great champion of equality. Isn't this private FDRs and arbitration, isn't that one law for the rich and one for the poor?
I can see why that's being said now, but I think if something works, I mean, effectively, I feel that arbitration is essentially at the moment being piloted.
Yes.
In the sense that it's not.
Do you think solicitors are reluctant to advise clients about arbitration? That's sometimes said.
I think there is a reluctance because the expression is that you don't pay for something that you come out worse for.
Yes.
And there's the risk of that. But I think that if it's shown that arbitration is a better process, I've certainly experienced that in the field of Talata. Yes. It cut out a huge amount of time.
Yes.
It was sensible. And the arbitrator was pleasant. The arbitrator knew what the case was about.
Yes.
And knew how to deal with the parties. The trouble is the courts are just too busy.
Too busy.
And it's an incredibly blunt tool. And I do feel that it's never going to be perfect in a situation where you have to go to a third party to get an outcome. But if there's a greater understanding of where somebody's coming from, you're much more likely to get an outcome that works for them. So yes. I'm a great believer in it, and I do think that it will feed down. And I think that there's a really good argument that this is one area where the government should be looking to invest. Yes. And say, well, you know, there's a specialist series. It's not just lawyers; it's all the other professionals as well that work with lawyers. Would invest in those processes, and I believe actually in your home country of Australia, they've started these family law centres, yes. And that may be something that we could import to this country.
My second home, equal home country, Australia. I'm both British and Australian, but I know what you mean. So you were talking about the courts being over busy, and that's obvious to all of us. And there's no consultation rooms, no privacy, etc. And
well, there's not even a court counter.
No,
I can't go into my local court. Neither can any litigant in person. It's actually very difficult to issue anything.
Yes.
You can have situations where really serious matters such as family law act proceedings or children act proceedings yes. take time to get heard because the court can't issue them. I'm not criticising the people who work in the courts.
Of course.
But the fact is, in a family law situation, the position might have moved on 2 or 3 weeks later.
Yes.
And it's a real, I think it's one of the biggest nagging concerns to me, yes. is that somehow we've got to find a way of getting that right. And we have to look at the parameters. I know the resources aren't there, and the government probably aren't going to invest anymore. So we have to be shrewd about what we do in terms of how we best serve our clients.
And what about the pilot project for having courts sitting earlier in the morning and later at night? What's your view of that?
I'm a bit cynical about it,
Yeah.
and I think the reason is not so much actually about the lawyers, and it is hard on lawyers because they have lives and they have families,
Yes.
but it's about the clients as well.
Yes.
And what they're being expected to do. Maybe not so much in London, but if it's in Wales or
Yes.
or somewhere in the West Country, and they've got to go 30 or 40
Absolutely.
miles at a difficult time of day,
Absolutely.
and there's safety implications.
Yes, indeed. Well, thank you very much. That's been a really interesting talk, and very, very good luck in your new role in the firm, and I'm sure you'll be an absolutely stunning success, and we will wait to see what happens constitutionally this week with Brexit, but see what the implications for family law are. Thank you very much indeed.
Thank you.